Hello, my name is Keith Vanover. I'm a DUI lawyer. I have a lot of experience in DUI law. I have personally handled more than 2,000 DUI cases throughout Northwest Florida. If you find yourself charged with a DUI anywhere from Tallahassee to Pensacola, then call my office right away. We can help you save your driver's license, but you only have 10 days from the date of your arrest in order to get this done. If you miss the 10 days, you can lose your driver's license. Call my office today. What does it mean when someone is driving under the influence? Driving under the influence, under Florida law, are two types of DUIs. One of them we call DUBAL for short. It stands for driving with an unlawful blood alcohol level. If you are charged with DUBAL, the state of Florida must prove two things in order to convict you. First, they must prove that you were driving or in actual physical control of a vehicle. And secondly, they must have a valid breath test that is over the legal limit of .08. There is a second type of DUI law under Florida law that we call it basically a common law DUI. This is when there is a refusal and there is no blood, breath, or urine test in your case. In that case, the state has to prove two items, but they're much harder for the state to prove. They must prove that you are driving or in actual physical control of a vehicle. That only becomes an issue legally if there's an accident case and you are outside the vehicle when the officer arrives. That could become a legal issue that we can argue. However, if you are pulled over and you're behind the wheel, that is an easier thing for the state to prove by just the officer saying, "I saw you driving." That's enough to prove that element of the crime. The second part, though, is they have to prove that you were operating that vehicle to the point that your normal faculties were no longer available to you. Now, the rough definition of normal faculties that is read to a jury is your ability to walk, talk, see, judge distances, react in emergencies, or otherwise maintain your daily life. Now, we're not allowed to comment on what that means to a jury, and it's a very unusual definition. But as you can see, that definition has a lot of gray area in it compared to holding up a breath test of over .08. And just because you have a breath test does not mean it's the end of your case, because we can get a lot of breath tests knocked out for technical reasons. So whether you have a breath test or you don't have a breath test, please give my office a call and we will give you a free consultation. We will walk you through the law and explain this legal minefield that you're walking through so that you can make an informed decision. Give my office a call today and we'd love to help you out.